Hi, everyone. Welcome to our BrightTALK original Privacy Insights Series webinar on how the CCPA, or the California Consumer Privacy Act, compares to the EU's GDPR. Okay, we've got some music going there. And so we're going to just wait about 15 more seconds, because we're getting people still stragglers, still coming on board. All right. So welcome. I'm your host today, Deborah Farber. I'm the Senior Director of Privacy Strategy at BigID. And BigID is a data discovery, inventory, data mapping, and data scoping platform that is helping enterprises manage CCPA and GDPR data protection rights. And I am heading up privacy strategies there. I have about 14 years of experience in data privacy, data protection, and information security. I'm a lawyer by training, but I have actually never practiced. I specialize in operationalizing requirements into business. And I'm really excited about the panel that we have today. First, Catherine, if you don't mind making a brief introduction of yourself.
Sure. So my name is Catherine Castaldo. I am a lawyer also. I've been practicing in intellectual property, which includes, of course, trade secrets and privacy, for my entire career, in addition to a few other things that go along with, generally protecting companies and commercial litigation and things like that. I've been outside counsel at couple of major law firms, and I've been chief privacy officer at 2 global corporations so far. So dealing day in and day out with these kind of requirements in the ever-changing landscape that we deal with, and watching it mature into something that hopefully continues to achieve the goals that the data subjects, I'll call them from the European term, or the consumers in the California term, would like to have.
Thank you for that. So I'm getting I noticed that there's feedback on the audio. If it's possible that when you're not speaking, if you can put it on mute, then that would be helpful. I'm not sure who that's directed at, but just let's try that and see if that works going forward. Deirdre, do you mind introducing yourself?
Certainly. My name is Deirdre Wheatley-Liss, and I'm an attorney as well. I'm relatively newer to the data privacy and cybersecurity area. I represent mostly closely held small and medium business enterprises. And I came to this because we had clients that were suffering under, I'm going to say, regulatory overload, as well as suffering actual cybersecurity incidents that we're looking for, how is it that we comply with these given the size businesses that we have, separate from an enterprise level for what it is that we're looking at. So when I'm looking at these things, as opposed to maybe what Deborah and Catherine are doing for more enterprise level, it's for more of your small and medium businesses. How do they make this part of, I'm going to say, the culture of their businesses moving forward?
Thank you for that. Really helpful. We also have Andre Krahel, who is joining us from LifeOurs. He's the digital forensics lead and the CEO and founder of LifeOurs. He is so LifeOurs is a global leader in incident response, digital forensics, ransomware mitigation, and cyber resiliency services. Oh goodness, everything is on an echo. So let me try something here. All right, I'm hoping that solved the problem. And Andre will be joining us shortly. He is running a little late from a call, but he'll be joining and chiming in soon. So let's get started.
Deborah, I joined. Thank you really for having me on this distinguished panel. My background is in the cyber military. I perform various missions for the United States, and we work very closely with Federal Bureau of Investigation and Secret Service on various cases that are related to cyber intrusions, ransomware, and cyber extortion. Thank you for having me today.
Thank you for being with us. Okay, so there's there are 3 people that are having technical problems hearing us, and I'm wondering if that's a challenge with the BrightTALK platform or the dial-in that they're dialing in, because we don't hear it as the presenters, and I don't know how to fix this. And no, you're not, as the person who wrote in, you're not the only one who's having this problem. But so we'll just move forward, because I don't know what else to do here. But and then hopefully the recording will be better later. Okay, so we're moving on to, and make sure all of you presenters, just make sure that you have no sound coming in through your computer, so that it's not a double feedback issue, and that you're on mute, I guess, when you're not speaking. So first we have in our agenda, let's talk about what we're going to discuss today. We're going to talk about what is the California Consumer Privacy Act, the scope of the CCPA, some of the similarities and what are the differences between the CCPA and the EU's GDPR, what is the impact and the limitations, and also the high penalties for CCPA noncompliance. And then we're going to ask our panelists for some steps to prepare for the CCPA compliance. And of course, we're going to allow time for your questions. So let's get into it. First, the California Consumer Privacy Act of 2018 has some new data protection requirements. This is the first of its kind in the United States, in that we really have had privacy laws that have been sectoral, but only now are they, with the CCPA, are there actual data protection rights that are afforded to individuals. And we're going to unpack that a little bit today. So the CCPA will officially go into effect on January 1st, 2020. And the California State Attorney General will be able to enforce for noncompliance beginning 6 months later on July 1st, 2020. This act grants consumers an unprecedented control over their personal information, and it enshrines in California law a significant number of rights that is very similar to GDPR. So to kick this off, Deirdre, can you give us an overview of how the CCPA kind of came to be, and maybe even tell us a little bit about the recent amendment and if the law is likely to change again?
Absolutely, and it's very apropos because we are recording this on November 6, 2018. And the reason that the CCPA came to be was that the California legislature was very concerned about a ballot initiative being on the ballot today, which would actually be much more stringent than what they passed for the CCPA. Having said that, I'm going to say this legislation was passed very quickly, not with sort of, I'm going to say, the normal process that you would go through, both from a legislative perspective and in having other parties being able to comment on it. There has been, Deborah, as you mentioned, an initial amendment, but I'm going to characterize that amendment as mostly technical in nature. It clarified some questions in terms of what were the limitations to the private right of action, when regulations are going to be issued, the effective date that you just mentioned as example. But I'm going to call it more of a cleanup bill because the fact that the legislation was prepared and passed so very quickly. Having said that, the California legislature has indicated that they are planning on taking up, I'm going to say, a more substantive view of this January of 2019. And what normally happens from the legislative process is that you have a proposed bill, you get feedback from all sorts of different interested parties, you revise the bill, and that ends up being the bill that's passed. Here it's a little bit different. They already passed the bill. The hope is that they're now going to take feedback from those that have to enact the bill, and there's some elements of the bill that there's a question of their enactability. And again, particularly from my viewpoint, looking at small and medium-sized businesses, the cost of being able to be compliant with this in terms of moving forward, that we hope that there will be some more substantive thought given to it next year. But other than that, it is the law as of January with compliance being effective as of July.
Thank you. That's a super helpful overview. And then now let's, talk a little bit about, what does the CCPA apply to? Like, what, Andre, do you mind kind of just unpacking for us what personal information means, and because that's what the CCPA refers to, and then, how does that compare to personal data under GDPR?
Okay. So in a legal framework, we classify what we call the personally identifiable information, and they might be very in nature, right? There is a classification, for example, PHR, personal health care information. So there are various classifications, what the sensitive data actually of an average consumer is, and how that information is consumed by the enterprises, by the public, by the government. And when sensitive data is being exposed, then that's what the harm really comes into a consumer. And what CCPA is basically inflicting is very similar to GDPR, where in GDPR in European Union, there is this notion that the privacy is a right of every citizen. So every citizen has a right to a privacy. So the CCPA provides private right of actions, meaning that basically it allows that individuals to pursue their own lawsuit or their own enforcement in the instance where his data is actually being exposed. And that's a significant movement because in the United States, the privacy has not been seen the same way as it is seen in European Union. Also in the United States, we use what we call the sectoral approach to a privacy or protection of consumer rights, versus in the GDPR, the European Union always had various regulations that and mandates that were basically across all the states, all the member states of the European Union.
Thank you for that. So the CCPA is going to, refers to personal information, which is basically anything that's linked or linkable to an individual, right? So Catherine, can you tell us a little bit about the scope of CCPA? Like what type of companies does it apply to, and do other companies in other states and countries need to comply?
Sure. Yeah, it does apply to California. And does this frequently, and have done it in the past with their other privacy acts in the healthcare space and some of the others. That they say that anybody that touches essentially a California resident is going to have to comply with their law, which is although we can't get federal privacy legislation in the U.S. here, California forces the rest of us to generally comply with what they decide as their is the way we should go, because of their being the most populous state, and with all businesses that have a commerce element in California. It ends up forcing everyone to sort of march in step with them. That being said, it is only applicable to for-profit businesses, so not-for-profits wouldn't have to comply. And companies that oddly would conduct their business wholly outside of California also don't have to comply. But pretty much any for-profit business with an online presence is probably going to touch a California resident and would be subject to the regulations.
Great. So, one of the interesting things I had come across is that one of the things that's not covered under CCPA is a publicly available information that's sourced from government records. That is not a thing under GDPR. For GDPR, even government-sourced publicly available records are still, covered by GDPR. Anyway, so I just wanted to point that out. And so there are some hefty penalties, and there's a right to sue as well. Deirdre, are you able to unpack that for us and kind of give a little more color to what the penalties are for noncompliance?
Sure. Before I get into that, one of the things I just wanted to comment on sort of what are the differences between the CCPA and GDPR in terms of what's personal information. One of the things that California did that's different is they sort of classified the personal information of a household versus an entity. And in looking at this, they're looking at, the Alexa devices, things along those lines that are collecting information overall regarding a household, which I think is different because Andre was talking about there's this individual right that exists in Europe that we don't have here. California is creating that right statutorily, but they're going beyond individuals to a household grouping. And even with the publicly available records, that they aren't specifically covered, to the extent that they're linked to something that is covered, that again is going to be, personal information that we're going to be looking at. And then one other question before I get looking at it. the question is it says that patients, if they can tell patients on the slide can say to stop selling information. It's actually consumers. Consumers have the right under the California law to tell companies that they are no longer allowed to sell their information. So what happens if they do sell their information? There are penalties that are going to be enforced. If it was a non-intentional violation of the California statute, it's a $2,500 per incident. If it is an intentional violation, it's $7,500 per incident. I think more importantly that people are very concerned about, though, is that there is an injunction that can be issued. And if you have a company that is processing data as their business, because this only applies to companies where more than 50% of their revenue is coming through the sale of this personal information or otherwise receiving compensation for transmitting personal information. An injunction is essentially going to shut you down. But I think the scariest thing, and Andre alluded to it, is this private right of action. So nowhere else do we have the availability of an individual in any other state to be able to go in and sue individually for what ended up happening to them. The private right of action right now is limited to damages from a data breach. So there was an actual data breach, and I can now sue you either individually or as a class because of damages that resulted from that. Importantly, though, the Attorney General of California has indicated that he thinks that this private right of action is too narrow. Going back to the idea that privacy is a right that Andre had mentioned, he proposes that the private right of action be expanded so that an individual, a consumer, can seek legal remedies to protect their own privacy just because their private data was misused, not necessarily that there was a data breach. And somebody had asked the question, what does this do from an insurance standpoint? Is this going to make premiums go up? And I would have to say yes, because, insurance, the premiums are a reflection of the cost of the risk. When the risk is regulatory, it's a little bit more manageable than these, individual lawsuits, class action lawsuits. So I absolutely do see it. We already have an unsettled environment when it comes to cybersecurity insurance, that this is just going to further that because of the fact that this risk is not quantifiable at all.
That's really meaty and helpful information there, and I know a lot of businesses are trying to, figure out what their level of risk is there, especially with the private right of action. Another interesting point is that that it's a kind of a self-funded regulatory schema, so the fines that are levied against, by the state of California are going to be used to fund the enforcement office. So, this will kind of carry with it, almost like the government's kind of incentivized here to bring actions because it will actually fund their ability to bring more actions. So it's certainly times have changed, and it's not business as usual. So let's now unpack some of the specific similarities and differences between CCPA and GDPR, especially around the rights afforded to consumers. So those rights that are in CCPA afforded to consumers are the right to know, the right to access, there's an implied right of data portability, a right to disclosure, choice regarding the sale of personal information to a third party. You can opt out of that, where there's a special rule for children under the age of 16, a right to request deletion, and a right to equal services and privacy. So I know, Deidre, we kind of ended with you on the last section, but would you mind kicking this off with telling us a little bit about the CCPA's right to know?
Yeah, so the right to know sort of absolutely has two aspects to it. The first is what's being collected, sold, and disclosed about me, right? So I have a right to have them, and this is very similar to GDPR. I have a right to know the information about me that's being processed. So what companies are that collect any of this personal information, a consumer, myself, could submit a request to them saying, what categories of information have you collected about me in the past 12 months? What specific pieces of information there were? What source did that come from? Did I give you the information? Did you collect it because you purchased it from a third party? It was because I was on a website at the time that you collected it and you collected it through there? What was your business purpose for collecting the information? And again, this is different than GDPR, because in GDPR you have to have a business purpose. There are these in order to collect the information. Here we're saying what was the business or your commercial purpose for collecting the information? Why were you doing it? And then the categories of parties with whom my personal information was shared. Was it shared with governmental agencies? Was it shared with other companies? What is it that you were going to be doing for that? The second piece of that is that in order for me as a consumer to know that I have this right to know, you, the company, need to tell me about it at the time that you're collecting my information. We need to have disclosures that are there that are saying what categories of personal information are collected and how they're planning on using the information. The company needs to tell me, the consumer, and remember, I'm talking in the online world, but this is not limited to online. It's anybody who processes private information, how it is that I can exercise my right to know, the one that I just described to you. Again, those categories that they are looking at in collecting the information, and then what categories of information did they sell and disclose in the prior 12 months. So I'm a company and I sold your name, or I sold your email address, or whatever it is that I did. Regardless of the fact that you may have agreed to it at the time that you signed up for my service, I now need to remind you that I'm collecting that information and clearly let you know how you can find out what information you have, which then leads back to, Deborah, the opt-out, which I think is one of the key pieces, and I know that we're going to be talking about.
Absolutely, absolutely. And so all of that has to be updated in your privacy policy, right? And so even if you kind of updated for GDPR and used all the right language there in your privacy policies, you'll now have to go back and make sure that it also accounts for CCPA's specific rights and as part of the right to know as well. So thank you for that, Deidre. Andre, can you tell us a little bit about the right to access and the associated implied right of data portability?
Yep, sure. So in CCPA, the further grant consumer is the right to access a copy of that specific piece of that personal information that the business basically has collected about the consumer or a household. And I like what the Deirdre said it about a household, right? One of the components of it, if you look at some of the breaches that we learned in the United States was, for example, and you touched on, Deborah, on that as well, are minors, right? And how you perceive the not just strictly just the email as a PI information, piece of PI information, but a whole that household, right? So ultimately the right to access, whereas the right is to know that only provides the consumers with that information about what categories of that PI have been collected, sold, or disclosed. The right to access provides consumer with a copy of that PII collected about them. So they should really be informed about what is that really that's being collected about them, what is being sold, or what is being disclosed from the categories of the personally identifiable personal information about them to the parties. The right may also imply some of the duty to preserve, and it's unlikely the right to know. The portion of the Act does not expressly specify whether business will have the obligations to preserve the PI collected about each consumer, only that the business need to provide a specific PI collected about the consumer.
Right, and so, upon receipt of a verifiable request, also, a business must provide the California consumer with access to personal information that's held by the business and to obtain it in a readily usable format that allows porting the data to another entity without hindrance. And so embedded in the right to access is also this implied right of data portability, very similar to the GDPR in that respect. So in this case, the right to portability is kind of wider and more restricted in the CCPA than in the GDPR. And so it's wider in that each response to a consumer access request for collected data must contain the data in a portable format if it's given electronically at least, without the consumer having to request it. And it's more restricted in the sense that the GDPR provides for direct portability between businesses, so between data controllers, so that the data subject doesn't have to be the intermediary. So thank you for that. And then does anybody else want to jump in on the call and add to that, the right of access or the implied right of data portability?
So this is Deirdre. I think, one of the key things when you're looking at, the question of specifically what are the differences between the two of them is the actual right to portability under the GDPR versus this implied right under the CCPA, because this is something then that's an area that companies are potentially able to push back on in terms of what it is they need to be able to do. And when you're looking at the cost of compliance, that may be an area where you say, okay, well, I'm going to provide the information, I need to have access to it, but I don't need to go as far as I did under GDPR, because there are so many U.S. companies that GDPR is simply inapplicable to, but they do business with California residents. Or alternatively, and I'm sure that we'll be talking about this, in my mind, this is a wave that's going to move from, the West Coast to the East Coast. This is not going to be the only data privacy regulation of a site that we're ever going to see.
Right.
So, in terms of where these areas of difference are, companies are going to be needing to look very carefully where they're spending their dollars in terms of what regulations do they in their specific businesses need to be applying to. And just in addressing that, I just want to answer one of the questions that came in through the screen, which is if somebody is covered by Gramm-Leach-Bliley, are they also need to comply with the California rules? And the answer is no. In the amendment that came out, they very specifically indicated that companies that have to comply with Gramm-Leach-Bliley are exempt from complying with the California Data Privacy Act.
Wonderful.
Thanks for adding that in, essential information. Okay. So
one more thing I would one more thing I would add to that. It's okay. Is that there's two pieces. One is that importantly is that companies that share affiliate brands or utilize the same brand can be drawn into, so that adds to the number of companies that may have to comply here. But that, and then to layer off of the Gramm-Leach-Bliley question, it's really targeted if you think about, the companies that are going to be the data companies that have caused so many of the data breaches in the past. And I think that's really what they were trying to target here, in addition to the security type breaches that we see in the credit card space. But now I'll let you go on and ask your question, Deborah. Sorry.
No, sure, no worries. Just tell us a little bit about the right to disclosure, and then, as part of that, also not part of that, but also separately, the choice regarding the sale of personal information to a third party. So I guess at first, let's discuss the right of disclosure.
Well,
and is this similar to the GDPR's, I'm sorry, go ahead.
I was just going to say, I think the main similarity between the two acts in fundamental pieces is the transparency element. They want to give people the ability to see how their data is being managed and how what the options are for that. There's a basic disclosure that can happen in a privacy policy, but then there's also anytime there are changes and they're going to have to give additional notices and additional rights to opt out if they're going to make a major change. The other, the conflict there, though, is going to be in between the two laws, not in California, but between California and GDPR, is that it only really applies to the sale of information. It's a very specific law in that context. As we all know, in GDPR, it's the use of information that gets the transparency and the requirements to opt in and to provide for the use under either legitimate business or a business purpose or some factor under the law. In California, it's only triggered when the entities are selling.
Thanks for that. And then it also seems that the CCPA provides a right to have choice regarding the sale of personal information to a third party as well. It's kind of similar, to the GDPR's right to withdraw consent, but really only applies to the sale of information. Can you kind of compare this right to, opt out of the sale of third-party information to GDPR, or what's unique about it under CCPA?
Is that for me?
Yes. Sorry.
Yeah. Okay. Sorry.
Question, please.
Yeah. Yeah. So as GDPR very, very clearly provided the ability that consumers had to, or I'm sorry, data subjects had to actively opt in. There could be no pre-tick boxes. If we were going to consent to data usage and data sharing, you had to consent through the opt-in process. In California, just like in many of our other sectoral regulatory provisions, it's an opt-out, but it is a much clearer opt-out than we've had before. This is and there are some interesting incentives for opting in or out under the California regulation, but it's definitely an opt-out. So there is the premise that unless you're a child between 13 and 16, that you will have the opportunity to opt out in this circumstance for the sale of information. But and the Act provides that the companies cannot discriminate for people who choose to opt out, and they can't offer essentially different services or products to people who choose to opt out. They can. There is a small part where they can charge a nominally different price if it's directly related to the cost of this. But I don't think we're going to see a lot of traction in that. But I guess we'll just have to see how it plays out over time.
Right. So what's particularly interesting to me is that companies that sell personal information or rent personal information, they're going to have to put a clear and conspicuous link on the bottom of the website with a call to action that says, "Do not sell my personal information," so that people can easily opt out of the practice that they want. And so that is a pretty huge thing, especially if you're a data broker or an advertiser. It's pretty much CCPA is going to have a huge effect on certain business models where data is, bought, rented, sold, and whatnot. And then the Act requires companies to keep a record of all sales for 12 months and be able to provide, here's what we have been selling. So this is definitely unique in as compared to GDPR. We have more of a opt-out capability here. And there's also, as you mentioned, Catherine, that there's a special rule for children under the age of 16, which when combined with our current law around the Children's Online Privacy Protection Act, or CCPA, it ends up really applying to children between the ages of 13 and 16. Can you unpack that a little for us?
So the provision is that there's no opt-out right for 13 to 16. They have to affirmatively opt in, similar to GDPR. And under 13, we have to have parental consent to be compliant with CCPA too. And there's California CCPA as well, so it's a mirror image of the other. So I think that's what the key differences are there. So companies who have an online presence, who conduct business in this way, are going to have to be particularly sensitive to the users that are on their sites, as well as ascertaining who those users are, and with some reasonable degree of certainty for who needs to be opting in or out, or who is capable of opting in and out, because not everybody is. The other piece I think that's important for companies to think about from that perspective is that we might think about it in like the cookie consent banner, or the other banners that appear on websites. If there's a banner that very clearly needs to state, "Do not sell my information," there's a psychological impact to that, and people are going to click on it. I think instinctively, not almost instinctively, but they're almost going to just respond to the fact that it says "Don't sell my information," because there's a strong feeling among the general populace that they don't want their information brokered. So it's going to have a real impact on companies if that's their model.
I agree. So I think that your advertisers, your data brokers, your gaming companies, social media companies, and any other business that's selling personal information, and when I say personal information, I'm including behavioral data and other derived data as well, they could suffer, hefty fines or lawsuits if they fail to put in place appropriate consent mechanisms, right? And I think that you'd also be able, you're going to, I'm predicting that you're going to see automated, access request reporting from companies who, from privacy activists who create tools that will just kind of find websites, crawl them to find these links, and then submit claims on their behalf. So now, I think companies are going to have to, especially enterprises, to respond to these access requests. We'll definitely need to put processes in place in order to be able to respond, really.
So I just want to comment on the point that Yeah, this is Deirdre. I just want to comment on the point that you made on selling, because it's not just selling data, it's transferring data for valuable consideration. So I think because of that, that there could be companies out there that do not consider themselves to be in the business of selling data, and therefore they don't think that this would apply to them. But the idea that came to my mind is, what if somebody takes the data that they have, they contribute it, let's say, to a research project because they want to then be named as part of this study, as part of their branding, right? They haven't necessarily sold the data, but because they've received consideration for the data, is it going to apply to them? So I just want to make the note that, that I think that what we think of as selling as non-lawyer human beings is different than what is contemplated for companies that are going to be covered under this, for those that are actually selling data.
Right, and so it's a little bit of a gray area until there's some case law there, or clarifications from the Attorney General. That's a really great point. And while I've got you talking and talking about kind of monetary value of data, why don't we jump to the right to equal services and privacy, Deirdre? If you can unpack that a little bit, that there's basically a right to. Basically, you want to incentivize people to pay extra in order to have their privacy, right? So, So what is this new right of equal services and privacy?
This actually, I think, is as again, as an individual, not as an attorney representing companies, but as an individual, is really the greatest element under the law. It's an anti-discrimination provision. It does not exist in GDPR. So basically, what it says is if I, Catherine, you were saying, what happens with this chilling effect if I have this opt-out button, right? People are just going to click on the button because it's there, and the knee-jerk reaction is, of course, I don't want anybody to have my data. And they then opt out of the data. The company cannot treat them differently in terms of accessing their service as a result of having opted out of having the ability to sell their data to somebody else. This is the hugest game changer, obviously, for all the companies that you just mentioned, that their business model involves collecting and selling data. If I say that I don't want you to collect and sell my data, you then need to provide me with the same information. Presumably their revenue stream is coming from collecting and selling that data. So now they're providing services to somebody who's not contributing to their revenue stream. So from a business perspective, I think that this is going to be the hardest thing to sort of be able to get your arms around. But from a personal rights perspective, this very much underscores how seriously California is taking not, again, as much the data breaches, but creating this right to privacy for its residents.
Totally agree. And I feel like it's a uniquely American approach where the CCPA recognizes that there is a monetary value to user data. And so there's an exception to, I wouldn't say an exception, but there's rules that allow you to actually collect a monetary data, there is monetary value to user data, and there's rules that allow businesses to offer financial incentives in exchange for user data in some situations. And so a good example of this is a company may offer financial incentives, including payments to consumers as compensation for, collection, sale, or the deletion of personal information. But the business may offer a different price, rate, level, or quality of goods or service to California consumers only if that price or difference is directly related to the value provided to the consumer by the data itself. And so now the question becomes, how do you value the data? Like, how do you know what the data is worth? And that's a good question you didn't ask. But the answer is that the Attorney General of California will be coming out with, guidance on that, and that hasn't happened yet. And we're all waiting for it. But a business is definitely not able to use financial incentive practices that are unjust, unreasonable, coercive, or usurious in nature. So, definitely something to be aware of. Okay, Andre, the last right. Can you discuss the right to request deletion? Is this similar to the GDPR's right to erasure, also known as the right to be forgotten?
And this is, for me, being a forensic examiner, this is something that's very interesting, right? So what we're saying under the CCPA and GDPR, we're basically allowing consumers to request the deletion of their PI from a business systems, meaning their servers, their storage databases, anything that would basically store their information. And then those covered businesses will be obligated to honor the deletion request, and unless it's necessary to maintain the PI, and I'll get into that component. But basically, the citizens now have ability to request the complete deletion of their records from the system. Now, I would say this is very optimistic on the GDPR and CCPA, right? Because some of the records, for example, that leak from those systems or are somehow embedded in the systems, they were not designed, the systems were not really designed with the fact that it can completely delete these records or metadata about these records or transactions that every citizen actually had them in them. So this regulatory requirement under GDPR and CCPA actually create not only to the businesses a challenge, but also technology companies that basically supply the equipment, databases, and systems, create this mindset that they do need to somehow structurally approach the data that's being collected, the PI data that's being collected on those systems. The complete of the transaction for PI that was collected, if that was provided as a good of a service requested by the consumer, or otherwise perform as the contract between the business and the consumer, then the covered business does not have to, for example, honor those transactions. And you already touched that point, right? So if there is some contractual, if the consumer, for example, monetize somehow his own data in the platform, then there is still this area of if the business should really honor the deletion or not of the transaction. And I'm sure that Didra can attest to that. But that aspect is still, I would say, being discussed under the both frameworks, how those cases would be handled. And my understanding is that the business, for example, right now, would not be actually obligated to honor those type of deletions from their systems.
Great. Thank you for that. And there's a question that actually came in. Are you able to anonymize data under CCPA in order to meet the requirement to erase that data under the Act? Like, would anonymization of the data be equivalent to erasing personal information?
I don't believe it would, because what really happens when you anonymize data, you actually need to have data derived from, right? So there is no one-way street. Like, if you want to go back and really understand what that is, what an individual is, it will be not possible in the same system. That doesn't mean that not third-party services right now that, for example, can anonymize your email or some of your PI when you enter into the transactions. But these would be like a third-party system that basically now interact with that covered business. And so the business would actually never have the data of the consumer in the first place. Technologically, it's very hard for the business create that conversion inside of the house. Then you would basically almost deny access of the PI data of the consumer by the business itself.
That's helpful. So it doesn't seem to make sense to do if you're architecting the business, but from a legal perspective, Deirdre or Catherine, do you guys know if you obscure the data, mask it, anonymize it, de-identify it, would that take it out of the meaning of personal information for CCPA purposes and then make it deleted or erased?
So this is Catherine. I think that what we suffer from here is a lack of guidance. And the working party in the European Commission has guidance on what anonymization is. It's a little bit dated now, but the fundamental premise of it is that it's a compilation of techniques that permit the data to be functionally anonymized. It's a pretty hard standard to meet, and it requires a continual evolution of those techniques in order to anonymize data appropriately. And then the other piece of it in this case would be, what does the company need the data for? If you need it demographically, then you're not really going to be able to anonymize it because you need certain aspects of that data in order to point to people's behavior to market to them if that's the kind of company it is. If, on the other hand, it's a different company that perhaps studies user behavior by, if we make the banner blue to more people click on it, that probably could be anonymized versus, a green or a red banner. So it depends on what the company needs to do with the data, why they're compiling it in the first place, why they're trying to acquire it from multiple sources, to see whether or not anonymization could be effective for them. But I still think ultimately it's going to be an argument of whether it's an effective method. Then we'll have to see that play out over time.
Right. All right, thank you both. Okay, so let's move on to steps to achieve CCPA compliance. I put some info here from, you want to update your privacy policies to include new CCPA data protection rights. You want to broaden that data governance effort to include personal information, right? You can't just do PII anymore, which is information that identifies a California consumer by itself. But now personal information is anything that's linkable or linked to an identity. And so you need to, make sure that you're going to include that in your risk management and your privacy governance workflows. You're going to leverage privacy intelligence and governance technology because it's really hard to do to manage these data protection rights at scale. And you're going to effectively manage consent and monitor data use. Otherwise, you're, if you don't have good consent governance and consent management in place, now's the time to do that because it's going to be very difficult to comply with this law without having technology that enables you to do it or to meet the requirements. So, Catherine, if companies have already prepared for GDPR, how much effort is required to prepare for CCPA in your opinion? And then, what about U.S. companies who have no business in the EU, have not started preparing for a comprehensive data protection law like CCPA? How much of a heavy lift are we talking?
Yeah, I think the biggest shock to companies that haven't done any preparation yet, the companies that already have are going to be familiar with their Article 30 requirements for the record of data processing activities, which is really their data maps, which are different, of course, from network diagrams. So any company that doesn't already have or has started on data mapping to understand what kind of data you have, where it's coming from, how you manage it throughout the system, and how you end of life it, really probably needs to do that in order to understand what their compliance needs for the California Act, and or whether they touch on any European citizen data. The other piece that I think that companies probably many companies I've known don't have the best handle on is their vendor risk management. So understanding who your vendors are, how they take your data, what data they're taking, what they're doing with it is important because that's going to be a clear point of selling data, even if the data perhaps is tangential to the other part of the vendor relationship. So there's that piece of it that I think we could consider. And then making sure that once you understand, what data you have, where it's going and how you're using it, where do you need to meaningfully provide that consent and transparency?
Great, thanks a lot for that. Andre, can you speak to how companies should prepare from a security perspective or even IT governance?
Yeah, so what's important is that every company, and it's not only related to CCPA framework, has basically fiduciary duty to safeguard the data of that consumer, which means that the way the data actually enter the system, they are processed by the system and they are stored, that there is enough diligence and care to protect the consumer information from public disclosure. Now, when we look at these various provisions, I would say they're quite repeating themselves on that fiduciary duty, but none of them really provide a framework or understanding for the businesses. What is the appropriate level of protections, care, the diligence? What that actually would be for each of the business? And when we go through various instances of events, incidents, and data breaches that happened in the last decade, there are various actions, for example, done by the federal regulators like FTC against certain businesses and entities and going back and forth. And not always government actually won the battle when they try to enforce some metrics to the process, the care process about the consumer data itself. But generally speaking, the normal application of encryption, authentication, access control, detection, monitoring, and breach prevention has to apply to the technology that's governing the consumer data under the framework.
Great, super helpful, thank you. And Deirdre, what steps should companies take to prepare from a legal perspective?
So again,
legal, I'm thinking lawyers, lawyers or the legal paper, contracts, that kind of thing.
Yeah, I mean, there's a couple of different areas. So, first of all, going back to Catherine's point about, data mapping, what do you have? Where is it stored? How do you collect it? And then for the California specifically, does this law apply to you? Do you sell enough records? Do you meet the gross revenue thresholds? Things along those lines. With small and medium business enterprises, they're so much less mature than our enterprise level companies in terms of even giving consideration to data privacy and cybersecurity as part of their regular business processes. So with that, from an internal perspective, once you're done with your data mapping, you figure out if this applies to you and things along those lines, you then need to have policies and processes in place to be able to deal with this. Specifically, how do people opt out? Can you track how you've used their information for the past 12 months? If you can't answer yes to that, you need to create a process in place to be able to do that, as well as a policy for your employees as to how they're going to be following along with this so that you're going to be able to be compliant. Secondarily, much of the private information that you have, you may then be sharing with third parties. What are those third parties doing with the information? So there's an exemption here in terms of, how it is that you're dealing with third-party information. And somebody asked the question, what if you're selling it as part of an M&A transaction? Well, no, that's not going to be subject to this because that's not part of your business operations. That's more of a one-time type of thing. But in terms of information that you may be sharing with third-party vendors that have access to your data, what are they doing with your data? You have an obligation to protect it. Are they meeting that obligation? So Deborah, from when you spoke about, we spend a lot of our time dealing with vendor management, which is very unsexy contract issues, making sure that when companies are contracting with vendors, that the vendors are assisting and not hindering the companies in meeting their responsibilities under whatever regulations it is that they're going to be looking at. Another one looking at, sort of the sale process. One of the things that I think companies need to think about, again, small and medium enterprise companies, if they're looking to be sold at some point in time in the future, data privacy is becoming part of the due diligence process. And somebody had asked the question, what if the company didn't follow the opt-out and we purchased them? Do we now have liability? And it's going to depend on how you structure the sale. Are you buying their assets or are you buying their equity? Because if you're buying your equity, you're buying their liabilities at that particular point in time. So this becomes a new point just from a business purpose transaction for what it is that they need to do. So what we recommend to companies is first you need to figure out where your data is. We already talked about that. But then secondarily, you need to engage in probably a year-long, if not longer, process of what are your policies and procedures, who has access to the data, how do you control the data contractually, and then very important, this isn't fix it and forget it, how do you then go back and make sure that your vendors are doing what they say that they are doing with the data that you are giving them access to?
Awesome. That's really great advice. Yeah, there's that definitely that data assurance piece. Like, how do you, do you add a right to audit in the contract? Do you, how do you monitor your vendors like that? Is it about how much room for negotiation is there in contracts?
So it depends on what it is that you're doing. So what we usually do is, we start with the matrix, right? How much data and what kind of data does this vendor have access to? And to your point, how much control do you have over the vendor, okay? Because I got to tell you, Amazon Web Services, if you're like an 8-person company, you're not negotiating with them as to how it is that they're processing data that you give them access to, right?
Right.
But in that case, then, what the company needs to do is they need to look back at their policies and processes to make sure that they're staying compliant with the data that they share with them. So, for example, we're a law firm. One of the things that we look at when we're utilizing cloud-based services are how any information that we put into those cloud-based services is being stored and utilized. And if there's something there where we don't have the opportunity I'm going to use Salesforce as an example, and I'm just using them just as an example of something that law firms use, that if there is no negotiating opportunity, then it's up to us as an organization to determine our internal policies and procedures so that we can access this business asset but meet our regulatory or confidentiality obligations simultaneously.
Makes a lot of sense. Awesome. And Catherine,
and I would like to just...
oh, go ahead. Go ahead, Andre.
Yeah, I would just like to expand that what Deirdre pointed out. It's super hard for these small businesses basically negotiate these contracts with the giants that actually do process, store, or leverage the information, PI information of the consumers. And when we do the forensic investigations, this often becomes a challenge because under none of these contracts, for example, the provision exists for them to actually somehow access those systems and even analyze what really happened. So this creates significant traction in the incident response space when we have to respond to a data breach or event of an incident contractually with these massive players in the market. And especially the cloud providers, the provisions, unless you are a really large entity, you might actually never have clear understanding what happened. And the response team are really in a mercy, or the answer to the questions, what really happened, how data was processed, how was it stored, how the attacker actually accessed, what was really possible in those systems is actually very hard to get. So what ends up being is, what we've seen is that the business actually becomes completely liable because the business picked a platform to operate, and a business cannot answer any of those questions. And the big individuals behind it just doesn't provide enough level of support to support in any or defend him in any legislative actions or contractually binding obligations the business actually has.
That makes a lot of sense. Thank you. So now let's take some of the outstanding questions from the audience. First, does deletion apply to just personally identifiable data or to transaction history? Who wants to take that? Jump on in.
Was this about deletion? Deborah, sorry, I couldn't hear you at the beginning.
Does deletion, so do you only have to delete personally identifiable data, or like would you have to delete things like transaction history?
So let me answer that question, right? So the PI means an individual's first name and first initial and last name in a combination of some of the following, like social security number, driver's license number, account number, medical information, health care records, right? So imagine the transaction actually captures in a certain sequence, right, the metadata, and metadata do contain pointing to that individual, pointing to his first name and last name, right, pointing to his social, pointing to his driver's license. So often in the computer systems, before data is actually being stored as that set, what I described as a PI, the transactional records, if you combine them, you can plot the picture and you can create a PI set for that individual, right? So this is where the challenge really comes in with the technology, that we didn't design technology to be necessarily compliant. We designed technology to be available and keep the integrity of the data. And then the last thing was the security, and compliance is now this new green movement into it. So every business has to, what Catherine and Deirdre already pointed out, do the data mapping, but not only data mapping what you have, but data mapping from, okay, I'm actually processing the data in a certain way. And if I do process them, what are these transactional records that someone can put together and create a PI set? Does that exist in my organization? No. And we call them often unstructured data, right? Unstructured information at organization. And I tell you, it's a massive issue even for large entities to come up and marry all those metadata and transactional records and come up with a meaningful solution for it.
Great. So just an FYI, we have about 4 minutes left before we will be cut off from the webinar will officially end. So there was a question about deleting data from backups, and what is that a requirement if someone wanted to delete that data? And so I wanted you to put out there that this is the right to deletion does have a number of exceptions, including detecting security incidents, complying with legal obligations, using the data for other internal purposes that align with the expectations of the individual, based on the relationship with the business, few others. but there is no clear exception for such data that's held in backups or disaster recovery storage. And so, yeah, this makes compliance more complicated because there's no exception. It's possible that in one of the future amendments to the law that there will be an update that has an exemption for data that's in backups or disaster recovery storage. But to answer that question, let's see. We could probably get one or two more questions in here. Does CCPA consider a person at a business address personal information like GDPR does? Catherine or Deirdre, do you want to tackle that one? Nope.
Well, I think it
okay.
could. I think it could. It depends on how what sort of information is tied with it. I mean, because I think the personal information definition in CCPA is very broad, and if it includes, because many people, do personal activities while they're at businesses, so depending on what information is being collected, it could. It doesn't necessarily mean that it always is in every circumstance. I think it's part of the evaluation of each business that this touches to understand what kind of data they have and where they're getting it from.
Great. Thank you. So let's see, what are our parting words of wisdom? Let's start with you, Catherine.
I would carefully consider the aspects of the law and how they apply to your business. I would recommend for every company to really get on those data maps if you don't have them already, and to continually update them. And then you'll be well positioned at least to deal with the questions in time for compliance if this is something you need to work on.
Thank you. And Andre, parting words of wisdom.
I've been part of many investigations and also many fines done by FTC and SEC. And my advice to the businesses would be serious about compliance, but also do not overthink. What government and state regulators are asking you is reasonably hold data of consumers. And as long as you can justify that you reasonably perform with your budget, with your understanding, with your limits, potentially there might not be penalties or might not be heavy penalties to that business. But there is no legislation in the U.S. that would try to put companies truly out of the business just by virtue of creating the regulation or legislative actions. What the intention of the privacy is really more to control the abusement of consumer data.
Thank you so much. We have 23 seconds left. I'm going to say businesses should broaden their data governance efforts to include personal information, leverage privacy intelligence technology, little plug there for Big ID, where I hail from, and effectively manage consent and monitor processing. With 9 seconds left, thank you everyone for joining us today. Sorry, Deirdre, for not getting your words of wisdom in there.